questioning why the fire sprinklers and fire alarm system did not fully function, questioning why the fire hydrants did not have water in it, questioning the lack of transparencies, financial accountability, openness, and compliance with the bylaws by plaintiffs. Question why are plaintiffs receiving checks in the sum of $50,000 without proper attorney itemized invoicing. Question the mishandling and commingling of $22,000 of client funds by plaintiffs. Questioning why plaintiffs would advise the association to spend approximately $100,000 to purchase burned-down units when plaintiffs' own legal notice stated that no proceeds would be paid to the buyers. Questioning why plaintiffs rigged the auction at the Sullivan County auction and billed the HOA for doing so. Questioning plaintiffs' misrepresentation, unethical behaviors, and misconducts. Question why plaintiffs violated people's voting rights and wrongfully denying voting rights of HOA members in financial distress after the fire. It is like denying voting right to U.S. citizens for not paying taxes. Question why plaintiffs are present and presides over every board of managers and general membership meeting. Question why do we need attorneys to sell vehicles posted on Craigslist. Question why did plaintiffs made a secret deal to sell HOA vehicle to plaintiff's father for about $9,000 and defendant, by showing up to the auction increased the bid up to $22,000. Question why did plaintiffs advise the HOA to purchase units at the auction without a membership vote as required in the bylaws. Question why are we paying plaintiffs $240,000 per year in legal fees when the place is burned down? Question why do we have to pay $90 per month for maintenance fees when there is nothing to maintain and no budget? Violation of Article 6 Section 1 of the bylaw. Question why did plaintiffs denied access to insurance policies knowing that it is needed to settle individual owners' claim? Question why plaintiffs are censoring, withholding, and denying access to entitled information. Question why did plaintiffs bill $5,000 for a $260 small claims case and did not show up in court to defend the case? Question what is the alleged secret agreement between Adjusters International for kickbacks disguised as legal fees? Question what is the deal with the about $2 million of steel removed from Grandview Palace? Plaintiffs refused to show the contract with High Ground Industries. Question why did plaintiffs allowed people to continue to live in a building without a proper certificate of occupancy and a death trap? Question why plaintiffs advised the board to rent office space in a building owned by the president of the board. This is a conflict of interest at the least. Question why did plaintiffs made a deal to keep us living in a death trap? There are many more questions but never an answer by plaintiffs. An attempt to remove the corrupted lawyers and the board of managers were illegally derailed by plaintiffs claiming that unit owners, protesting a wrongfully charged maintenance fees, cannot speak or vote at a general meeting. This is against the bylaws. Plaintiffs are going overboard to hide, protect and to exercise full control and authority over the board of managers and the association, just to further their profits and power. Answers to all these and many more questions resides with plaintiffs and they refuse to abide by the bylaws and make these answers public, and when defendant and others tries to do something about it, defendant gets slapped for speaking out. All defendant and the victims of the largest fire in Sullivan County want is information, explanations and to be kept informed. Instead plaintiffs choose to hide and censor entitled information. Plaintiffs tried several times to coerce defendant in taking down the Facebook page. On or about February 6, 2013, defendant and others became tired of questioning plaintiff's improper representation of Grandview Palace and filed an absolute privileged document naming Attorney Preliminary Inquiry Form with the State of New York, Supreme Court, Appellate Division, 3rd Judicial Department, Committee on Professional Standards, Defendants Exhibit 8, petitioning the government for help. Plaintiffs replied with this frivolous SLAPP. Strategic lawsuit against public participations. Defendant is publicly known to be an advocate and leading the rebuilding efforts for Grandview Palace, leading the fight for transparencies, financial accountabilities, openness, and compliance with the bylaw, an opposing position to plaintiffs and the Board of Managers of the burned-down Grandview Palace condominium complex. Defendant is a known, outspoken, open critique of the plaintiffs and the Board of Managers. Defendant appeared and interviewed 9 times by local television and newspaper, publicly expressing his opinions in opposition to the Board of Managers and plaintiffs. See Exhibits 1, 2, 3, 4, 5, 6, 11, 12, and 13. Defendant and others contacted many governmental agencies seeking help to stop plaintiffs and the Board of Managers' suspected, unethical, and illegal activities such as alleged in this complaint: bid rigging, failure to produce itemized bills, mishandling, and commingling of client funds, misrepresentation and misconduct. Defendant has seen checks paid to plaintiffs for $50,000 without proper attorney invoicing. Plaintiffs have no likeness for defendant and Facebook since defendant and others' public petitioning and participation, activism and encouragement is raising public awareness to plaintiffs' unethical behaviors and true motive. Plaintiffs initiated and continued this claim in a malicious prosecution based on sheer ill will, which constitutes an improper purpose. Defendant has proven that plaintiffs resents him and wants to harm him. Plaintiffs, by filing this frivolous lawsuit, lacking probable cause, acted with malice towards defendant primarily out of hatred for and ill will towards him, and with the intent to vex, harass, or annoy him. This is a vexation litigation that is brought, without merit, solely to harass and subdue defendant public petitioning and participation. This is a frivolous lawsuit, which is burdensome and unwarranted filing of a meritless claim without a cause of action. Plaintiffs are abusing the judicial process and must be sanctioned. Plaintiffs filed this SLAPP libel pro Southeast suit in direct response to and in retaliation for defendant communications with governmental entities and for filing an attorney complaint seeking redress of grievances, to bring attention to issues of public interest concern plaintiffs' fitness and competency as attorneys for the 396 unit owners of Grandview Palace membership.